costs except for the actual cost.
Right.
So, I mean,
There's no benefit you're talking about. There's no.
yeah, there's no benefit to the community. It's actually part of the contract that we already accepted through our last RFP process.
Is this for the employees of the county, or who'll be attending this conference?
It's actually for all county departments is how we do it, and since it's the health department.
It's we're sponsoring it, but the actual participants are coalition members. The coalition is a coalition of hospitals, a coalition of hospitals, long-term care facilities, and others who will have to work with if there's ever an emergency.
Right, we understand the benefit to the community. The question is whether we need to do findings for the fee outweighing that statement we do, but I believe it's actually already in our contract.
Since we sponsor this, I would say no.
Yeah.
Okay, fair enough.
Very good, thank you.
Okay. So a motion to be in order then?
Move that we approve and authorize the commission's signature on consent agenda 19.
Is there a second?
Did we lose him?
Commissioner Ivey, are you there? It's that mute button. Well, I will second that. All in favor?
Sorry, Bill, I had that on mute and I thought I hit the button, didn't I?
Yeah, that little mute button, now it gets no.
Yeah, I had the tractor and then was trying to cut the background noise out.
Okay, so would you like to second that motion?
Yes, I will second that.
Okay, I got a motion and a second to approve and authorize the commission's chair as stated number 19. All in favor, say aye.
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 That passes 3-0. Okay, now on to number 27, is to approve and authorize the Third Amendment Agreement, talking about Rocky Mountain University, their health professionals. There's been some discussion with this from our last time we did an approval. With this intent was coming back for some findings. Mr. Moore, if you'd like to address that.
Sure. So I was asked to draft an amendment to the contract that would essentially waive the rent for Rocky Mountain University. In exchange, they were going to perform some additional services for the benefit of the public for waiving that rent. So I prepared a draft and put it on your agenda. I heard back from some different commissioners as to the content of that draft, and I'm looking for further direction from the commission. The draft that I created essentially tied the waiving of the rent to those additional services provided. It was a little more specific, and I'm not sure if that's what you wanted or not. I wasn't sure, so I just took a stab at it. So give me some direction. I'm happy to make any adjustments as necessary.
So for me, on this one, I voted to waive the rent because of the benefit to the community that Rocky Mountain University currently provides. I know by waiving the rent, it gives us additional services to the county, which is what's represented in this 4.4. I was actually already good with waiving the rent on the services they provide, knowing that they will continue to be a big benefit to the community. So for me, I don't need anything in there specifically. I don't care if we want to put that statement about how the benefit to the community outweighs the fee. If we want to put that in there, that's fine for me, but I don't care if there's anything personally.
Okay. Any thoughts, Commissioner Ivey?
I had the same feeling that I felt like waiving the rent was acceptable given their current contribution to the community far outweighs, what we're waiving.
Okay. I feel the same way. If I could just maybe put, and so if we were to strike 4.4 in there and put in there that the benefit outweighs the cost that we get to the community, and put, like we've traditionally done when we waive these things, that there is maybe a 1-year look back in which they come and report to us.
Sure.
I think that would be
I like
totally
that idea.
acceptable.
That way the public also knows the benefit.
Yeah, so we can see it.
So what I would need to do is I'll modify 4.4 in the Third Amendment, that's what we're talking about now, to reflect a annual report
Yeah,
to-
in commission meeting.
in commission meeting, and essentially just
Highlighting
providing for a
their
full waiver.
contribution to the
Sure.
community.
Sounds good. Did you want to approve that today, or do you want me to bring it back next week?
I think we can just go ahead and
I'm,
approve it
I'm
today
okay
with that.
approving it today with those changes. I
Okay.
have the confidence in you to make those changes.
Right, I would be very much in favor of approving it today with the noted changes.
Okay,
Is that a motion then?
Yes, I will make a motion to approve the contract with the noted changes.
Okay, and I will second.
all right, I've got a motion and a second to approve and authorize the third amended, the 3.1 amended, after we amend it again. That was a joke, sorry. As stated, number 27 with the modified changes as talked about here. Any discussion
No.
on that? All in favor?
Aye.
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 That passes 3-0. Okay. Number 29 is to approve and authorize the commission's signature on an amendment to an agreement, 2016-641 with Provo City, clarifying the funding sources for the West Side Connector. Richard, if you could just kind of walk us through this one, after reading it. I personally don't see any concerns. I think it'd be good just to walk through this and talk about what's going on there.
Does that not have a button on it?
Oh, I can't read that. I haven't got my glasses on. There's an agreement with the Provo City on what's known as the West Side Connector or Lakeview Parkway. It's all the same road that goes from the University Avenue interchange down past the airport. Now we're past the new high school. The agreement had an amount of $15,950,000. When the original agreement was done, there was, I believe it was $500,000 that was tagged as the registration fee or corridor money. As the project has proceeded, they haven't had enough of the corridor monies used to where that money's locked up, but that corridor money is very specific in what it can be used for. What this agreement or this amendment would do is free it up to where we can utilize up to the 15.9 million for all of it out of the sales tax dollars and make it so that we can make them whole on the project. There's about, Sean, 600,000, is that the right amount around there that's remaining on it?
So, again, I don't have any issues with this. It has come to my attention and from a couple different cities, since you brought up corridor preservation, this isn't necessarily with this item, but corridor preservation.
Two different things.
Right, they're frustrated, and that's why I'm telling you, since Mag's also here, they can, they're frustrated with some of these cities. We're not releasing the corridor preservation fund. We're not reimbursing it fast enough, so whatever we can do, if it's on our end, Mag, if we can get some help to make sure, because some of these cities don't have very large budgets, and
Sure.
and it can be a pain. So anyway, you said corridor, and it reminded me that I needed to talk to you. So,
Okay, any other questions?
no.
Nope, any other questions?
None.
All right, seeing none.
I'll move then that
motion.
we approve and authorize the commission signature as stated in number 29.
Second?
I've got a motion and a second to approve and authorize the commission signature as stated, number 29. Any questions on that motion or concerns? All in favor, say aye.
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 That passes 3-0. Okay, 37, we struck that one. Okay, number 39. The reason why most of the people are here is to adopt a resolution appointing the interim replacement for the Utah County Sheriff. And you want to go over the response we got from the party?
Yeah, is the party not here with, they thought the email said he was coming to give a letter. I don't see him. That's all right.
Just go ahead and read
Okay.
that letter, if you would.
Okay, so, we received a letter from the Utah County Republican Party, yesterday stating to, this letter is to certify that Mike Smith is the elected Republican nominee to fill the vacant office for Utah County Sheriff. A Utah County Central Committee meeting was convened on August 18, 2018, wherein Mr. Smith was declared elected by acclamation as he was the only candidate to file his intent to run for the vacancy. Signed by Heidi Baldery and Rob Craig of the party.
So with that letter and following the process, it comes to the commission for a vote. And we left the line blank on our agenda because we submitted it before the Saturday meeting. So it would be appropriate to put his name, Mike Smith's name, in that line and then take a motion and vote on that.
I just want to make sure Mike Smith is the legal name, full legal name. And that was my question when that came. I'm sure we need the full legal name.
We'll use it.
Michael Lynn. Okay. Are we ready for a motion? Commissioner Ivy, did you have a comment before I make a motion then?
No comment. You can make the motion.
Okay, I will move then that we adopt the resolution appointing an interim replacement for Utah County Sheriff, adding in the resolution the name Michael Lynn Smith.
Second.
I've got a motion and a second. Any comments to the motion, concerns? With that, a vote, all in favor?
Aye.
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 That passes 3-0. I would like to give Mike an opportunity and to just address for a couple of minutes, if you'd like to go that long.
He told me 64 minutes is how long he'd prove.
Commission, thank you very much for the time to speak a little bit this morning. I've got to tell you, I had set in my mind as we went through this process, you know, you have all been through the same process, and you know how hard it is, how stressful it is. And as we progressed through the process and we made it through convention and then the primary election, I'm thinking things will kind of calm down, and now there's a plan. Put an email out to my department saying, hey, I'm not going to be a lame duck chief. I'm here for the next 6 months. Let's get some stuff done. And then here I am. Things didn't go the way I thought they would, but this is good. I'm really excited to be able to step in as the sheriff and to do some things. I know there are some issues that I'm stepping into that have come before you, and I'm excited to be able to get in with you and work through those issues and to be a team in that and solve some problems and work forward as a county and as a sheriff's office. So I'm happy this has happened. I am really excited to be able to step in and work with the fine men and women of Utah County Sheriff's Office. We've planned a swearing-in ceremony that will happen at 1 o'clock today, just across the courtyard at the historic courthouse. I would love all of you to come. You're all invited to come. I promise it will be a quick ceremony. We're not going to drag it out. And then there will be an open house right after that up in the ballroom. I believe that's on the 3rd floor. Is that right?
Right.
And that'll go to about 4 o'clock. So thank you very much.
All right.
Thank you and welcome.
Welcome. Even though you haven't been sworn in yet, we're still going to call you sheriff. How's that? Chief Sheriff. There you go. You're wearing 2 hats right now until they get replaced, right, in Pleasant Grove? Yeah, okay. Well, welcome. That's good. All right, let's move to the next agenda item.
Commissioner, I apologize. On regular agenda item 1, I forgot. There was a request for a quick discussion on if we could move that time up from 6 o'clock. I know the intent was to also allow the public to come, but staff and some of the people have expressed possible concern with the meeting at that late, if there's any way to maybe address a different time. I know this is on the special meeting for September 11th.
Well, let's pull our calendars up, take a peek at it. So maybe just let's pull it off of our consent so that we can have a discussion with it. You don't want to just pull that off.
Do I need a motion to do
Yeah,
that?
a motion to just pull it off.
Move that we pull regular agenda item 1 from consent.
I'll second that.
Okay, we got a motion and a second to pull agenda item number 1 off of consent. All in favor, say aye.
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 Passes 3-0. Okay, so calendar-wise, take a peek. Do you have your calendar with you, Commissioner Ivy?
I don't have it readily accessible at the moment.
That works for me, looking at my calendar, so we can pull it to an earlier time.
Yeah, I'm available. I know that we have the employee appreciation luncheon that day in
Right.
the afternoon.
But that's,
That's it.
Um,
I just want to make sure there is a requirement, this is Paul Jones from the Attorney's Office, there's a requirement that our public meeting be at 6 PM, but that's the December meeting, right?
You're asking us for a
Yeah,
legal?
yeah, we're,
This is not
Well-
required to be at 6 PM. It can be at your normal
Okay,
commission meeting.
just wanted to make sure that we're okay time-wise on that.
Yeah, we already looked at this.
Oh, okay.
All right.
so if
So
it can
what's
be in
your-
our commission meeting, then do we even need to notice it as a special meeting? Do we want to have a special meeting and do it at like,
So you're
3 o'clock
proposing to
in the
take it
afternoon.
to our commission meeting?
well, that's what Rob just said,
Well,
it's
you could-
possible.
You have it set for as a special meeting because you have it set at 6 PM.
Oh.
You
We have
could
set
make
it
it as
six.
part of your.
But part of the thought for the later start time was for public, to make easier public participation.
Yeah.
That's up to you.
And that's, so I would personally prefer to have it later in the afternoon or evening time so that we can get that input on this item.
Yeah, and I'm not disagreeing. I know what the intent was. That, all I'm saying is with a commission meeting at 9 AM and where staff does need to be involved, and that also to do at 6 PM, that was the request. It just creates, unfortunate, but I know September 11th, I believe, is also the deadline. That's the last day. So,
I don't remember, it wasn't the last day, it was just
Okay.
kind of a day that seemed to work well.
so maybe we move it to a Wednesday the next day, or,
I'm inclined to have it as convenient as possible for
public.
the public.
I agree. Like I say, I was just asked, and so staff asked me to bring that up, and so, for discussion. Maybe we go,
My preference would just be to leave it where it's at, because I think that's a great evening to have it.
what if maybe we go at 5? Just to speed it up a little bit.
Yeah, I don't know 5 or 6.
I don't know.
I think we just leave it at 6.
Okay,
My personal preference is just to leave it at the 6 o'clock.
and that's fine with me.
Yeah, okay. Well,
Okay. Then I will move that we adopt an order to call the special meeting as contained in regular agenda item 1.
Second.
Got a motion and a second to adopt the order calling for a special meeting on September 11th at 6 PM here. Any questions to the motion? Seeing none, all in favor?
Aye.
Aye.
That passes 3-0. Okay, discuss and approve or deny, this is number 3 on our regular agenda. This is to discuss, approve, or deny a tax sale protest that was filed. I know this was one that was continued. If I remember correctly from this one, we were hoping that that the two parties would be able to work things out offline. And I don't know if I've never heard if that came to a conclusion or not, but we've got Bert coming up here to go ahead and walk us through it.
Not so much walk you through it, Bert Harvey, Clerk Auditor's Office. Not so much walk you through it, but just kind of let you know, I believe Mr. Wiseman's here to speak on his part. There's also a representative from his tile company that's on their way in. I don't know if they're here yet. Oh, they are here.
The only
so-
question was, because we continued it because we were hoping that,
Right.
I made a comment and said, it sounds like this nuisance piece was bought just so he could make some money.
Right,
The guy who bought it at tax sale literally got up and said that exact reason.
right.
And so all the commission made a point, and we said, please go and do it. We just want to know, did that get resolved, or do we need to take
Well, and
action?
I'll let I'll let any parties here that be able to talk to that, because, anyways, I'll get out of the way.
I don't know if I should introduce myself. I'm
Yes.
Teldon Wiseman. I'm the homeowner with the easement issue. After the meeting, what was it, like 3 weeks ago or something, the last time that we talked about it, Anthony and I met in the hall and exchanged information. And I told him then and there, like, my intention is to file a claim with my title insurance policy that was purchased with the sale of the home. And I did file the claim, and I've been assigned an adjuster or somebody to gather all the information, excuse me, to send to underwriting or whatever. and I'm currently holding right there. I don't have any update other than that. I've been in, with the exception of the last week, I've been in pretty regular contact with Anthony, giving him updates, like, this is where I'm at, this is who I'm talking to. He's been very cooperative, but I am forcing them to take care of it, because it's not really mine to take care of, I don't think, so.
So you would be in favor of us continuing this,
Not really.
So,
till the title company
yeah, is
does
the
something?
title company, she raised her hand. I'd kind of like to ask her a couple questions. I guess the first, well, sorry, you
Sure,
didn't state.
state your name.
I am Lisa Napolis, and I am with Highland Title Company.
Okay. So since he has said he's made a claim, I guess my question is, for remedy or going through the claim, what would be your course of action? How long does something like this take? What would you guys do if you
Well,
find error?
What I'm hoping to do here today, what actually happened was the order was placed on the address of the home. In doing the search, it was not clear that there was an additional parcel because it was originally lots in a PUD. And after the subplat was recorded, the neighboring lot, there was a portion split off, given a whole new tax number and everything. That is the portion he's talking about. So there is a strip of a neighboring lot, which is taxed
So after the
completely
approved
separate.
subdivision, if I understand this right, the platted subdivision, somebody then went in and changed the boundaries that create this overlap or this nuisance piece, as I have
Correct.
often call them. And so when it got recorded, it wasn't recorded inaccurately. Their surveyor gave inaccurate data that the county recorded or something like that.
Well, apparently, it looks like maybe the property came over a little bit, but that wasn't clear on any of the original plat. This was all done subsequent to the original plat being filed. So in the transaction, it was never noted that there was an additional parcel. In the search, we would have had no reason to look beyond the original, parcel, the original lot. So that's why it was missed. We were not aware of the tax sale until Mr. Wiseman contacted Stewart's title agency after the tax sale. So we are completely prepared to pay the taxes, if that's an option, the back taxes, to remedy this. But that is essentially what happened, is it was never brought to our attention that there was a split of the neighboring lot and that a portion was supposed to go to that property.
So I gotta ask a clarifying question from, maybe I misunderstood what you said. As I heard what you were saying, it seemed like you said that the lot that Mr. Wiseman's in, you went around that one and got that one all cleaned up, but there was the neighboring lot that the split came from?
Correct. The neighboring lot was split.
It was
and-
never the split from Wiseman's lot?
No, it was not from Wiseman's. It was from the neighboring lot. So
So how would Mr. Wiseman then have claim to that strip?
Yeah, for real, is it my yard or not?
It is,
I-
it was in the ownership of the sellers, and the sellers had never disclosed the fact that there was an additional parcel. And so from what I saw, it was never, it should have been part of the transaction, but the sellers did not give that information. And Mr. Wiseman's property is Lot 48, Plat A, Thanksgiving Village, PUD. The strip is a part of Lot 47, Plat A, Thanksgiving Village, PUD. That was broken off and
Because
then,
that makes a difference for me in my thinking. If it seemed like it was a mistake where both parcels, the strip and Mr. Wiseman's, was a mistake, then I would say that he'd have some claim to it, some kind of claim to it. But if it never was a part of that, then how could I sit here and say that he has claim to it?
the developer, after they had recorded their PUD plat, had broken off that little strip, and I believe it's because of the way that things were laid out on the properties. They realized they had an overlap. But it was the developer that broke the part away from Lot 47 to give to Lot 48 after the fact. But it was never noted on Lot 48 that also a portion of Lot 47, which you usually see
Yeah,
in one tax number, this was given a whole separate tax number and basically made its own parcel.
And so
But
since it was broken off from the other plat, it almost seemed like that neighbor has more of a claim to that.
Well, it was intended to go to lot 48.
Yeah, no,
It was
you-
the intention of the developer to go to lot
It
48.
was intended for that?
Yes.
Yes, because you can
Okay.
see that this strip actually goes up literally to the corner of his house, which would violate the easements set aside in Lehigh City.
Yeah.
That's the
So,
problem.
yeah, so it should go with lot 48.
Okay.
It was just something that was done after the
I'm just trying to
fact.
make that tie for a claim here. Otherwise, the tax sale, in my opinion, would be a legitimate, and I'm not saying it's not, but the sale would go through because it's not an error. It was there. It didn't necessarily belong to that lot, so how can there be a claim for it?
Well, just to clarify, so what she's saying is all correct. The chain of title here that we're looking at is the reason Mr. Wiseman was notified of the neighbor notice and why we're notifying is because the prior owner that he purchased his property from, that strip had been titled to that former owner. So when the transaction took place, so yeah, this all happened and the strip was created. But that strip, when it was created, was then titled to the former owner who Mr. Wiseman bought his property from. So that's why Mr. Wiseman is part of this process versus if we'd notified their neighbor.
So Mr. Wiseman would never have any understanding differently than to think that was part of his parcel
Correct.
already.
Correct.
So he's the one that's been harmed in every aspect of this transaction.
I can see the tie now.
Yeah.
All right.
Okay, so Bert, if I remember, since this is going back, then if the commission so chooses, it has the option to set aside or in essence deny the tax sale
Right.
and allow the back taxes to be paid, which the title company has said they would pay him on behalf of Mr. Wiseman, which, like, I remember Commissioner Lee stating this, our only obligation is to collect the tax.
Right. Right.
So is that, if we found that, we would want to deny?
And
If we-
yeah,
if that was the
yeah,
road
if the
we go.
commission feels that that's appropriate, the commission is given, I believe, broad latitude, and of course, legal counsel can confirm that or tell me if I'm off base there, but the commission is given broad latitude to accept or reject bids that are made at the tax sale. If you find if you have a finding of fault or if there's some cause to do so, we have not ratified the sale. We've not issued a tax deed yet. Once you issue a tax deed, essentially it kind of leaves our jurisdiction to be able to do anything. There's ways we can undo it, but it requires a lot more recording. So if the commission feels there's default in the sale, then it certainly is an easier process on our side to roll back the sale, refund the money, and allow the taxes to be paid and taken care of before we obviously get to next year. So,
Sure.
but yeah,
Uh-oh, legal, you said legal, now he has to go.
I know. That chill down the back of your spine.
Thank you. Yes, the commission does have the ability to overturn the sale or accept the sale. I do think the commission is in somewhat of a difficult position because in every respect, the sale was conducted appropriately. Mr. Wiseman was never due any notice from the county because he wasn't the owner of this sliver. So the clerk auditor's office followed every procedure that they were supposed to follow. It might be my recommendation, I think the county might be in the best legal position if they did continue it and tried to allow the parties to continue to work it out.
Yeah, but we've done that and it's not gonna happen.
But we have a claim in and it sounds like it is proceeding.
Yeah, but again, the title company willing to pay the back. The problem is see, and this is what Mr. Wiseman doesn't realize, there's more than just paying this back tax. This is gonna continue to be an issue. What I would do if I were him, I would not only get my title company to pay the back tax, but I'd make them pay the county fees to make this a whole piece of property again, because otherwise this is gonna be an issue every so often, because it needs to be made whole again.
That's a conversation that's been had.
Okay. Because when we have these, normally these don't sell at tax sale. And the county ends up getting them, and eventually we find the right owner, we sell them, we waive it, or we sell it for the cost of administrative fees to make this a whole piece. So to me, I'm not finding fault in what our clerk auditor's office did at all. But in keeping, in my opinion, in keeping consistent with what this commission has always done in making these whole pieces, which is why we refer to them sometimes as a nuisance piece, it would be wholly appropriate to set aside that tax sale and fix that issue like we've done. That's how I'm looking at it. Not that the person who purchased it was wrong, not that clerk auditor was wrong. There was a harm created by to the homeowner and at none of his fault either. And so to me, it's kind of like, unfortunately, we're finding a way to split the baby, and not everybody's going to be happy, but that's where I'm at.
But saying that, our intention is to record a deed, to put those both into one tax parcel number, so it does not happen again, because it would require a lot more to make it one lot with having to do an amended
Sure.
plat. So we'll just make it one tax parcel number.
Okay, fantastic.
Okay, and I,
Go ahead.
For me, I'm good with just annulling the sale, voiding the sale, and collecting the tax from the title company and having them move forward.
did you say awarding the sale or denying this?
Denying.
Oh, denying, okay.
Denying.
Okay. Yep, and I feel the same way.
Okay.
I'll make, let's have a motion then.
Okay, I'll move then that we deny the tax sale as stated in number 3, with the changes, noting that the title company is going to pay the back tax and amend this to be one parcel of property.
Probably be approving the tax sale protest.
That's why I asked specifically.
Oh, okay.
Okay,
Yeah.
then, whatever sets this aside, then I will amend my motion to say approve the tax sale protest as stated in number 3.
I will second.
I've got a motion and a second to approve the tax sale protest as stated in number 3. Any discussions to that? All in favor?
Aye.
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 That passes 3-0. Thank you. Okay, number 5. Richard, come on up and talk about this one. This one's a long one. I know we've had some discussions with it, and this is,
Yes.
go ahead.
Thank you, Commissioner. Number 5 is a action for the commission to refer to the Planning Commission to get a recommendation from the Planning Commission for what they call the roadless rule, petition for the rulemaking for the roadless rule on the Forest Service. We have been asked by the state of Utah to go through a public process to help prepare a petition that the state's preparing to go to the Department of Interior and the Forest Service to look at the roadless rule that was created back in I believe it was 2001. It's when that actually went into effect. What this does, that it provides an opportunity for the county to have input with the Forest Service on how the forests are managed in development of forest resources, in utilization by the public, in things like commercial logging that can help with the wildfire situations that we have. What we're doing today is just basically referring this back to the Planning Commission. We would then hold a meeting at the Planning Commission, get input there. Once the Planning Commission's made a recommendation, it would come back to this body for your review, another public meeting there, have input, and then ultimately go with a recommendation to the state for inclusion in the state's process to the Forest Service. They have asked all 29 counties of the state to do this. We are also working with Bryce and his team on making sure this is consistent with a resource management plan that was approved a few months back, so that we have consistent documents there. So that's kind of where this is at. If there's other questions that you have, I'd be happy to try to answer those.
Nope, I'm glad that we're gonna go through this process. It's been a long time coming. I'd like to see something happen on a federal level with it. But first, we'll address it locally. And of course, with our county resource management plan, I think there's a lot in there that we at least tiptoed around with it when it comes to this. Any other questions? This is just a referral,
Correct.
refer back.
No
and so
questions from me.
Our refer back process, they'll go to them, they'll go through the whole process, and they'll come back to us for some sort of for a vote on it.
Yep, and I would assume, Rob, probably a resolution would come from this body. Would that be the appropriate action at that point?
At that point, yes. You don't have to have one for today.
Right.
Okay, thank you.
Thanks.
A motion would be in order?
I'll move that we approve to send item number 4 to the Planning Commission, as
Aye.
stated.
5?
5, sorry.
Second.
Got a motion and a second to take action to refer number 5 to the Planning Commission. Any discussion on the motion?
Nope.
Seeing none, all in favor, say aye.
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 That passes 3-0. All right, we continued 6 and 7. Item number 8.
I know there are some, just so the commission's aware, for public comment on 6 particularly, so at the end of the meeting, public comment, even though we've continued that item for further discussion next week.
Yeah, okay.
So,
Walk us through this.
Okay, this is Paul Jones with the Attorney's Office. So the state of Utah assesses value to certain property holders in the state of Utah, and we refer to those as centrally assessed properties. And so the tax rate for those properties is based on the value that's set by the state as opposed to being assessed by the county. And those property owners, those assessments come out in May, and then those property owners, there was an amendment to the law this year, and those property owners have basically through July to protest or to appeal the valuation to the state tax commission. And then the counties have basically, I think, another 30 or 60 days from that point to become parties to that appeal process. We are affected as a county by the valuations placed on the centrally assessed properties. And maybe even more importantly than that, property owners in the county, their tax rate will be adjusted based on the valuation of the centrally assessed properties. So if the centrally assessed properties are decreased significantly, that means the locally assessed properties, the tax rate will go up on the locally assessed properties to compensate for the decrease in the centrally assessed properties. These properties listed in the resolution have appealed the valuation, and we actually passed a resolution similar to this a few weeks ago on Pacific Corp. And because of deadlines, our deadline for them was earlier because they had appealed earlier, and now our deadline is coming up on these properties now because they appealed later. And so by this resolution, Utah County would become a party to the whole appeal process at the State Tax Commission or at the court system after that, if it gets to that. And so by this resolution, you would authorize my office to sort of keep tabs and become a party to the valuation appeal process for these companies.
What do we do with properties? I mean, centrally assessed usually means that they cross over boundaries, right? We centrally assess because they're in multiple counties. But what do we do with properties in which there is not that multiple crossover?
Well, I would say,
one county?
I'd say centrally assessed is more tied to the type of property, more than just that it crosses over county lines. Centrally assessed takes care of your utilities, your railroads, your airlines, and your telecommunication companies. Whether they cross over, most of them do cross over county lines. Also, for example, centrally assessed takes care of your mining properties, and so you might have a mine that's just in your county, and it doesn't cross county lines. It would still be centrally assessed.
Which most of them actually do cross county lines. A lot of them do.
Yeah, but like a gravel pit maybe wouldn't, and I think those are centrally assessed, and stuff like that. So properties that don't cross over county lines, I'm not sure. So again, I think the real question, it would be use of the property. In fact, we could probably check with our assessor's office, but we probably do assess some property that crosses county lines, and we have to work with the other county in that assessment process. Maybe, don't know. Rarely, but it probably happens. So basically, property is either going to be assessed by the county or be assessed by the state.
Yeah.
And the state has their list of properties that they assess based on use or based on ownership. And so for us to be involved in the valuation appeal process, we have to pass the resolution by state statute.
And so anything that is centrally assessed, then, if by passing this, we would be able to be a part of the conversation.
If that property owner has appealed their valuation.
Only if they've appealed the valuation?
Right.
What if, and I know there's a guy behind you that wants to comment on this. What if there's really no valuation on the property?
What
How
if
can they
there's no
it?
appeal?
Yeah,
So the county actually does have the ability to be the initiating party on an appeal, but state code requires, and this was changed by the state legislature within the last,
2 years ago, Senator
A couple
Bramble ran
years.
this bill.
yeah.
right.
And the new law says that we have to have a good faith value, or we have to have a good faith basis to believe that the valuation is 50% of the actual valuation. So we have to have a good faith basis that the valuation that the centrally assessed, that the state assesses to a property owner is half of what it should be. So if we think that it's at about 75%, we cannot appeal that. It's got to be, we have to believe that it's half of
Okay.
its value.
So, and I'm probably stealing some thunder here on it, but I'm gonna ask the question anyway. So if there's a piece of property that's not being taxed and it doesn't have a certain amount of value at all, can we petition as an appeal process to the State Tax Commission to find out what's going on there and how we can get it rectified?
If it's not even being taxed at all,
Right.
Because if it says 0, obviously it has value. So it'd meet the 50% threshold, because $1 over 0 is more than 50%.
yeah, so, and,
Yeah.
so
I mean,
again,
right,
we,
exactly.
we could look at it, is it exempt for some reason? And, you know, I don't know what property you have in mind here,
I do, knowing what's behind it.
possibly Snowbird, I don't know, but.
Oh, no, this is not.
No,
this
Oh,
is-
it's
okay,
not.
oh, okay, yeah, oh, I don't know.
This is a separate piece.
So if it is centrally assessed, the question would be, is it centrally assessed or locally assessed, or should it be centrally assessed or locally assessed? And then, what's the value? And if we believe that the value is at least twice as much as they're claiming, then yeah, we could be the initiator of an appeal.
Because the problem is when you bring up mining claims, for example, when you're talking centrally assessed, whether it's an active mine or a non-active mine or what can be mined is part of what goes into their process, and that's kind of part of the dilemma here.
Right, so if you are talking about a mine, my understanding is that the mining valuation is strictly based on what they're pulling out of the ground.
Right, and therein lies the problem. But see, that's the other problem with centrally assessed. Some of these mining claims go to companies that aren't even in existence. So how in the world can you challenge them?
Yeah, I'd be happy to take a look at it.
One other question for you. Why did you call this the CAT resolution? You always keep calling it centrally assessed properties, yet not CAP, you did CAT.
Well, CAT, centrally assessed taxation, or centrally assessed tax.
I know, but we never call it that.
CAT's
That's why I
fine.
wondered. So anyway,
I thought maybe, yeah.
May I fill in a few blanks?
please.
Mark Allen from Protect and Preserve, American Fork Canyon. We are a property owner in the midst of 1,500 acres of Snowbird's property. They were able to purchase property and keep it off the radar of the public for decades because of central assessing. Back the year that Gary Herbert was put in as county commissioner, central assessing came out and said if mines are not actively being mined, they should be locally assessed. Because that was not uptaken by the county at that time, Snowbird was able to purchase property and record it up in Salt Lake with central assessing and end up with 1,500 acres that the public had no idea of under multiple shell companies. So a few years ago, we purchased a half acre of property. It's a part of the Bow Russia claim. We filed a warranty deed and we've done a survey that we spent $10,000 on and did everything through the county. I have been in front of Senator Valentine and asked to pay my taxes for 2 years now. Because the system is 180 degrees off whack, we have problems in Little Cottonwood, Big Cottonwood, and as well as American Fork Canyon, wherein if it's not locally assessed, the recorder doesn't map it. So if you look on any county plat map, all of Little Cottonwood, Big Cottonwood, and American Fork Canyon show that they're public lands. So I'd like to get a tax ID for our parcel, and I'd like the county to start mapping things. The data set in talking to the county recorder and some of those historic things, it's very arduous. On our team, we have the former Surveyor General of the United States that has been helping us. We spent 10 days surveying, looking for historic corners, monuments, and so forth, and it's not easy. But we did it, and we've accomplished it, and our parcel is mapped within a centimeter or two in accuracy. The ski resort has come in and said you can't hunt up in certain areas. Well, they can't show you where their boundaries are. And the handheld GPS units don't show you what the maps are at all, still shows that it's public lands. If the county commission would say, so in pushing this through and trying to get Senator Valentine, if you look at the statute, it says if it's not actively being mined, it should be locally assessed. For 5 decades, nothing has been actively mined in Little Cottonwood, Big Cottonwood, or American Fork Canyon. You go up past Tibble Fork, you can see a sign that says since 1969, there's been no mining. There's a little bit of placer mining, a few guys that do pan mining and so forth, which should, I think, should be continued. But if the county commissioner would just simply say, mining activities in American Fork Canyon are illegal unless permitted through us, it would throw a curveball at the State Tax Commission. And because when I go to them, they keep saying, okay, you have to turn a bond back in. Okay, now you have to have the lady that you bought the property from approach us and say, we're not actively mining. Or you have to put a conservation easement on. They say the onus is on the property owner to say, I'm not mining. Well, good tarnations, when was the last time Snowbird or Alta or Snowbird or any of those guys were mining? So the tax basis, we may be missing out on a lot of money for our county based upon that. If the valuation is what they're taking out of the ground versus recreational sales, we may have lost out on millions and millions of dollars because we have not acted. So I would like to pay my taxes, and I'd like to see Snowbird's boundaries made accurate, and I'd like to see the maps made accurate. And it's really amazing to me, it's 2018, we can't figure this out. I wonder if it's preferential treatment to the ski resorts from the State Tax Commission. I don't know. But for them to be so reticent to say, Mark Allen, we're going to make it hard for you to pay your taxes, we're going to make it hard to get an ID, that's a first for me. Because most of the time they're digging their hands into my wallet. So I'm here begging to pay my taxes, I'm here begging for a tax ID, and I don't know what we need to do it. But if we follow that process, all the mapping will naturally be an outcome of that. Fran Eichbush would be happy to sit down and talk to you about the BLM data set. It's probably the most accurate data set. It's the easiest path to getting this stuff done. It'll take burdens off of your county surveyor who's willing to go up and spend a week shuffling around up there. But we had the chief cadastral surveyor from the BLM come. He's willing to help if we will just adopt this. The incongruency is the state has a data set, the BLM has a data set, and they don't talk to each other. So we purchased our property here, and the state doesn't know that we purchased our property because there's no two-way communication. It's just push from them down. You guys send out valuations, people pay their taxes, and there's no updating. So anyway, I would love to see this on the docket. If you would just simply go back to Senator Valentine and say, good grief, there's been no mining up here for 5 decades. We're going to start doing what we were ordered to, and just take the wind out of their sails. It will change the mapping up in Little Cottonwood Canyon as well. And so here's the reason that's important. There are hundreds of abandoned mines up in Little Cottonwood Canyon, as well as American Fork. Some of them are huge liabilities to the public and the watershed. There are intended land swaps now between the ski resorts and some of those lands. We don't know what the maps are, we don't know what the liabilities are, and the public could end up with a $500 million boondoggle ownership of abandoned mines that we have to clean up to protect our water. So until maps are made accurate and liabilities are figured out, there should be no land swaps whatsoever, because we may wake up and realize that we're going to have to, for the next 50 years, treat our water. If they take it one step further and put a national conservation or monument designation, there will be no way that we can clean it out. So for the rest of time, we will be paying to treat heavy metals coming out of the canyon. Anyway.
You brought up something that was interesting, and that is creating an ordinance. Because Commissioner Lee worked very hard representing the commission on our land resource management plan. And an ordinance for mining coming through the commission would probably be in conjunction with that resource management plan. Would be an interesting look. That's a great idea.
Well, there's an incongruency between the Forest Service plan and the CE1 zone.
Right.
So in our parcel, we'd like to put a yurt up there. I can't do that. I can raise pigs that can excrete all over. I can raise chickens, I can have a dog kennel, but I can't put a yurt up there and pack in and pack out human waste and let people camp overnight. The Forest Service plan would allow me to do that, but the county plan is incongruent. On our team as well, we've got Peter Karp, who's a former superintendent of the Uinta National Forest. And he was the one that crafted that Forest Service management plan. That should be harmonized with what the county is doing as much as possible. Anyway, thank you very much.
Welcome to the slow-moving bureaucracy of
all good.
Government.
We'll get there.
All right. Thank you, Paul, for that. I think this is a step in a direction for us. We, of course, want to be involved. At least I feel like we want to be involved in
Yep.
in the process.
Do you mean on these specific appeal processes?
Sure.
Or?
Yeah,
Or everything, yes.
Or everything?
Yeah.
well,
Yeah.
specifically since this is on our agenda, yeah, we want to be involved in these for sure.
But we do want to be, yes, that's what I was thinking.
Even though I don't like the term CAT, because you've never called it centrally assessed tax ever. I will move then that we adopt the resolution as stated on regular agenda item 8.
Second?
I've got a motion and a second to adopt the resolution as stated in agenda item number 8. Any discussion on that motion?
Nope.
All in favor, say aye.
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 I think that was an aye.
Yeah,
Okay,
sorry,
That's three. The motion passes 3-0. We'll move to 13 and 14. Let's see. 13 was continued. 14. Number 14 is to approve and authorize an application for a personal information protection of law enforcement officers. We did receive an email from Sandy Hoffman talking about a process in which she works through as well. And Rob, if you'll like to just kind of walk us through this in the two different cases here.
Sure, and I have not seen Sandy's email, but this application is statutorily required this year. And what it relates to law enforcement officers only. So it doesn't apply to judges or prosecutors or anyone else. It's a super protection of information for law enforcement officers. So this form essentially just walks down the statute and puts everything in the application that is identified in the statute. So I've tried to stick pretty close to the statute. So what happens is a law enforcement officer can apply here, and then the departments in the county have to protect certain information of that law enforcement officer and their immediate family. This application is good for 4 years, and it protects such things as address, telephone number, personal mobile telephone number, pager number, personal email address, personal photograph, direction to locate their home, photographs of themselves or immediate family members, home or vehicle, voter registration, et cetera, and marriage license applications. Those are some of the things that are protected by this new law that went into effect for law enforcement officers. There is some other provisions in here related to when that happens. It advises the law enforcement officer that if we can't know how to get to your home, it may affect when emergency personnel need to get to your home. It may also affect when zoning things happen in your area. You may not get notice, for example. So there are some negatives to applying for this, but for the most part, it's a benefit to law enforcement officers. It's statutorily required. It's a separate form. We have other forms similar to this in the county now to protect information, but this is a new one by statute, and it, again, only applies to law enforcement officers. So it would apply to our deputy sheriffs, basically. And that would be it.
And there's
So-
a second application then?
There is a different application. I've seen other applications that I've been given before that had a broader scope. It applied to judges and prosecutors and others. This is not that form. This is different because this is, as I said, this is kind of a super protection, if you will, of that information. A little more, little additional protection.
So you
And
said
this is a
one,
different stat.
and you said one of the things that's protected in there, which is interesting because it's protected, but it's not protected, and that's the personal email. Because it's protected from us giving it out unless they use it in their duties as, if they used it for county business, then it becomes public again.
Sure.
So
There are also
for all
penalties
deputies, make
if
sure you
we,
use your county email. not
once
your-
the application is filed, there are some penalties if we don't take care of this.
Right.
And protect this information. So be advised that. We also have them identify us on that's allowed for in the statute. So I put it on your agenda mostly to make you aware of it. Hopefully you'll approve it, and if you do that, then I think I'll meet with the sheriff's department and then make sure they're aware of it so they can start process of protecting their information if they so desire.
And so with that, the concern is that this becomes the application, but in essence, there probably are two applications one that is the super protected one that you're talking about, in which we're gonna follow law. We're gonna,
Yeah,
obviously, we're
it's-
gonna
yeah, it's
follow
statutory.
state statutes, so if that's what the state statute is, that's what we'll follow. The concern is that Sandy says that I noticed that it does not have a place where my office can put a serial parcel ID number, no place to check off what type of at-risk employee the person applying is, and does not state the valid government-issued ID is mandatory. So there's things that are missing
Well,
from the
it does have those
application.
things. So let me show you on the form. And I'm happy to, if we want to continue the week, I'm happy to sit down with Sandy and look through those. But
Well,
for
I think this
example-
is following state statute. I'm not worried about,
Yeah.
we want to follow state statute. I'm just wondering if we're going to have two separate applications.
I haven't seen her email, but the things you just mentioned to me, it does reference the address of the officer. It does have it in bold in the middle of the application. Please attach a copy of picture ID from your qualifying employment. And I even have a footnote attached to that, which shows that's required.
Okay.
So those things are addressed. The one thing you did mention that maybe is not addressed, I think she said tax serial ID number, is that what she said?
Yes, serial parcel.
It actually is
ID
addressed
number.
in number one. It's actually underlined. If records are in the office of the county recorder, blah, 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 blah. You don't have to receive the official notice and announcements.
Yeah, it does have the home address. It does not have the tax serial ID number. We could add that. I mean, that's not a problem.
Well, see, and I took that to mean because it says are in the records of the office of the county recorder treasurer. We already actually have that. That's why I figured it was. Maybe it's not. I mean,
So
I know
I'm
I
happy
can
if you
get
want me to
7
meet-
attorneys in there and get 7 different opinions, but to me it was.
Well, again, if it's to help them identify the property that
Easier.
that the law enforcement officers want them to identify, I think that's fine. We can include those things.
So with it, this is not a time-sensitive thing
No,
by any stretch.
absolutely not.
So would it be wise for us then maybe to just continue it for a week to just have that conversation and make
There
sure
is
that
an empty box on
we're
this
all-
application. We could add it very easily.
Absolutely.
we're all on the same page? I
Yep.
think that would be wise to
Yep.
do.
We could do that.
Then I will move that we continue item number 14 for 1 week.
Second?
Had a motion and a second to continue item number 14 for 1 week, and maybe outside now with the discussion part, outside of that motion, that Rob, you'd be responsible to go and meet with Sandy.
Yes, I'll do
Okay,
that. Thank
okay.
you.
Any other comments or concerns there? All in favor, say aye.
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 That motion passes 3-0. Okay, number 17. I know we've had this one's been continued. This is to adopt a resolution amending the Utah County Human Resources Department rules and regulations. As stated, it deals with line of duty deaths, survivor income benefits, and so forth. It was continued. This was a continued item from January 7th, July 17th. Who's gonna deal with this one?
Well, we asked for those changes in that meeting, and they've been added the way that I remember us talking about them in my review. My notes, they match what the entire commission's discussion was, so I'm actually okay just to move on.
Let me ask a question if I can get to my notes just to clarify. Okay. Does this apply to all employees?
No,
Not yet.
no. As drafted, I think we were just trying to clarify what direction. My recollection of the last meeting is we kind of had different opinions from the
Yeah, we
commission.
wanted to do this one and then go back and draft one that wasn't public safety.
So I'm looking for direction, if you will. If you have a different, right now, what it says is currently we allow for is survivor income if an employee passes away, if he dies.
Right.
We have a survivor income benefit for the employees. What number 5 that added in here to our HR rules would allow for a line of duty death survivor income, which is a little bit different than the normal survivor income, only that a survivor income right now of an employee's spouse would cease when that spouse remarries,
Right.
which has been somewhat consistent with Social Security and how they've addressed this over the years. And this has been a policy that's been in place for many, many years in the county, county government. And so this line of death duty survivor income would not have that restriction. So if a
Well,
officer's wife, so if an officer passes away, is killed in the line of duty, and his spouse survives, and the spouse remarries, they would still be able to enjoy the survivor income.
Right, but if I can attempt to, I think what Commissioner Lee's question was, I think he's recalling a conversation where we talked about doing it consistent for the whole county.
Whole county.
And the reason in checking with my notes, because that was actually what my memory was, and then when I checked my notes, it was Rob that in the last meeting talked about the reason we need to do it separately is because line of duty actually is a statute. There's actually, not statute, that's how the state refers to it, line of duty, because of the public safety versus the
no.
other.
But
You
you
can
could
do
have
line
the
of
whole
duty.
thing. Yeah, you could just change the survivor income in section 4 to remove the remarriage not prohibition, that sounds harsh, but to remove the restriction that if you get remarried, you lose the benefit. We could remove that and have it apply to all employees, if that's what you desire to do. I think last time, as I recall, we weren't quite all in accord as to what, and so we asked to bring it back to this date to kind of look and see what we wanted to do, and I'll make those changes and we'll adopt it. 'Cause it's
Where is it in number 4?
Because from following our discussion,
So all you
Like
want
I-
to do
like
is on
I-
the 30%, just take off marriage.
I
On
just
the-
want
on
to make
survivor
it,
income.
I just want to make it across the board. I think a death is a death. I mean, some's horrific and some are a little bit different, but I think it's a benefit to the county employee.
No, and
employees
I
and their
agree.
families.
All I'm just saying is, I like having the line of duty in there. In number 4, when it says 30% paid to surviving spouse, if only a spouse survives, 2 spouses age 65, to be consistent with the other, and strike off the or marriage. That gives us the uniformity for all employees.
So let me give you some kind of additional information. We have, I believe, approximately eight employees, spouses who are still enjoying the survivor income benefit.
Enjoying is kind of a weird term
I-
for
I-
a surviving
Yes, it is.
benefit.
It is. And I apologize, it sounds that way.
Right.
But they are utilizing the benefit. If they get remarried currently, they would no longer have the benefit. There have been other surviving spouses who have gotten remarried and who have been taken off of the benefit, the survivor income benefit. The question is whether you want to distinguish between a survivor income for general employees versus a line of duty death survivor income that would only apply to, say, sheriff's deputies and employees. That's the question. If you say, no, I want it to apply across the board, I can bring this back with it applying across the
I
board.
personally would like to see it across the board.
Okay.
And that, me too. I don't think we need to bring this back. I think we can leave the survivor income. I think we can leave the line of duty. They both would match. That way, just distinguishing, because we do already have 2 types of employees. We have public safety and we have the
Well,
other.
you wouldn't need the line of duty. If you made it, I could modify.
My point is,
we
I'm
just
okay
took-
with this staying in there. I don't care. We just need to strike or marriage in there, in the survivor
Yes.
income that's already in there.
Okay.
Now,
And
go ahead. Sorry.
I was just going to say, I, for the sake of easing the conversation, I am fine with it being across the board. I had originally proposed it as line of duty for reasons I'd mentioned in the previous meeting, but I have no objections applying it across the board, and so I think we can pass it today very simply as well. We just simply modify and drop the upon remarriage provision that it ends, and then it's done.
Yeah. Now, Rob
and
brought up
then
another.
anyone that lost a spouse, then they're going to get that coverage for the rest of their life.
Right. Now, well, till 65.
65, yeah.
Rob brought up a point, and I this is my stance on it. We do have some that have been remarried that have subsequently lost it. It's not my intention to go back and reimburse. It's my intention, because now it's a policy change. It was done in conjunction with the policy, that if they so choose to come back on within this policy, they can be active again on it, not a retro, and
Not
starting
retro.
right now.
Going forward.
Yes.
Yep. Moving forward, not retro, it'd just simply be moving forward.
So,
Thank you. Let me clarify one thing. In addition to, if you see the 30%, which mentions spouse age 65 or remarriage, there's also a provision about children till they turn 21 and it refers to unmarried children. Would you also want me to take out
Yep.
the unmarried portion
Yep.
related to children as well?
Yep, 'cause
That
that's gonna
applies
be
in
in
the
my motion.
40% and in the 20%.
Yeah, and that's, yes.
All right, so I will do that. I will modify section 4. You will not need
Well,
section 5.
we're gonna do it in the motion,
Thank you.
so.
Okay.
Okay.
So you feel then, if I could just summarize it then, that this is countywide and not just particular to law enforcement? And-
That's correct.
And it's a
It would apply
benefit
to
to the.
me if I pass it
It
in my
applies
speech.
to,
Yeah.
yes. Okay, that's, that,
And there is a cost associated with that, obviously.
of course there is.
Sure, and we're okay paying that cost, it's the right thing to do, in my opinion. Okay, so I will make a motion, and like I say, if you don't like it this way, I'm more than willing to amend it. It would be my motion, then we adopt the resolution with the following changes. In section 4, remove the or marriage in, under the 30%, and strike the unmarried children in the 20% portion, leaving in number 5, line of duty death, but making both the exact same policy for all county
We need to
employees.
leave.
That, and that's why I
And
say,
I think we could just take that out.
that's my point that I'll amend, because I don't care either way, but where we have public safety in the other, I'm okay distinguishing and having it that way.
We just don't need it.
Oh, I know we don't, but if we want to just
Yeah,
show,
let's just drop it.
okay, and strike number
Make it
5,
simple.
okay? There we go.
I'll second that.
Okay, I've got a motion and a second on agenda item number 17 with some changes as stated. Any comments to the changes or motion?
Nope.
All right, all in favor, say aye.
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 That passes 3-0. All right. That was number 17. All right, number 19 is to adopt a resolution approving and authorizing the execution of an interlocal cooperative agreement between the Transit District of Utah, also known as Utah Transit Authority, and Utah County. I know we've had at least discussions with lawyers back and forth, and I thought I saw Steve walk in. Oh, there he is, okay, back there. Let's see, Rob, would you like to kick us off with this and kind of walk down through what that interlocal agreement is, as stated on our agenda, is and where we're at? Okay. Commissioner Graves is just stepping out for a second.
Sure. So, Mr. Shawcroft from our office has been working on this, and he is not here today, but there's been an interlocal cooperation agreement, proposed interlocal cooperation agreement, been floating between the UTA and Utah County. We have been working through this, talking about what if a quarter-cent sales tax were to be imposed, what would that look like, and how would that function here in Utah County? And what we've come to was that there would be certain provisions that this would apply directly to, and that's reflected in a local cooperation agreement. For example, the quarter-cent, if it was the quarter-cent, the fourth quarter were to go into effect, it would go into effect and pay off the O&M, for example. It would work towards our bonds, number 1, O&M number 2, and that's our existing bonds, existing O&M related to BRT. It would continue on to cover, and it's identified in this interlocal specifically what provisions it would cover in succession. So depending upon how much money is generated would be what it would cover. So if there's sufficient amounts to cover the bonds, they would cover that first. If there's O&M, that'd be second, and so forth and so forth. And as we've talked back and forth with the attorneys, we have reviewed the languages in this interlocal. I think that we have found them acceptable from a legal standpoint. The only issue outstanding is there was a proposal a discussion by the county to require for any new transit service in Utah County that they would be subject to the prior approval of the county, which approval must be obtained by UTA prior to the commencement of such new transit service. UTA has some concerns with that language, and we have not come to, at least from the legal department, come to a conclusion with that on resolving that issue. So that's what is outstanding between a resolution between the attorneys. Now, obviously, we're not the decision makers here. We're just drafting the document, and we were under the understanding to include that provision in this interlocal, which is now before you today. If you decide to approve this interlocal, and then you also have number 20, which would be the imposition of a 20.25% county option sales and use tax for highways and public transit, or sometimes we call it the fourth quarter cent sales tax. That should be subject to UTA approving this interlocal, assuming that you approve it today. So to restate that, if you decide to approve the UTA number 19.
So let's address those separately, because.
Okay, we can do that.
Because see, there's a difference in what you're saying. I'm not disagreeing with your logic, because I'm with you on 19, like, this is coming from the commission. But the problem is we can't agree to something, then vote to put something on the ballot hoping UTA does it, because the ballots have to be printed very
Correct.
soon.
And we've made
that
UTA aware of
creates
that.
a problem.
Yeah, so Dave and I, Dave was in a discussion with the attorney for UTA and mentioned that, look, we have ballots printing this week, and so we have to have a signed agreement from UTA if we're gonna go forward.
And they'd be subject to.
Yeah, you'd obviously have to have that this week. So the question is, and I think it's been drafted in such a way that it's gonna go on the ballot, and that's the direction that was given to us, if you decide to approve it, that's the approach you'd wanna take. If you decide you don't wanna do that approach and not put it on the ballot, then that's also your choice. But if you decide that you want to approve the local cooperation agreement today, then UTA would need to also approve it. And then, and number 20, you would be looking to put that on, if you decide you want to put that on the ballot, you'd be looking to approve that as well. But if you do that, you'd want to approve it subject to UTA approving the interlocal cooperation agreement. That's a lot of talking, but I don't know if I.
Yeah, I'm sure there's gonna be a lot more, so we'll,
Okay.
there's, maybe a little bit of back history on this. The fourth quarter cent sales tax, was voted on in this county, and it was rejected, resoundingly. It was.
And pass in any city, actually, if I remember right.
There was one city, I think it was, if I remember looking at, I think there was one. And so on a legislative basis, I know we were up on the Hill trying to change the dynamics there legislatively, which we thought we had in place up till the very last day, last eve, last hour. and things changed from what we thought was gonna be passed, even to the point to where the next day we thought that it was already in place, and it was not. It had been changed the last second. And so we wound up with Prop 1 again, the same Prop 1, except for this time there was, and I'll say it again like I have in the past, there was a big bribe out there, which was about $22 million if we just went ahead and didn't consult or have a vote again up from the people and just impose it as a county commission. And $22 million is nothing to sneeze at. So it becomes a serious conversation. As a commission, I know we talked about what can be done. So we're looking with this interlocal agreement to do it on a contractual basis, what we could not get done on a legislative basis. And that's the intent of this interlocal agreement, is to find a way that we can, one, bring control back to local control, and then use it appropriately, and second, to put it before the voters to see if they agree or not. And that's a big if. It's still a big if out there if the voters will go for it. But if it's Prop 1, again, the same thing, I can almost tell you right now, it's gonna get shut down. Without changing these dynamics in the county and bringing back some more local control this direction, and paying off some of the debts that we have, I think that that it's not gonna move forward. So with that, Rob, I also want you to go through, there was some talk about statutorily requirements, what can and can't be done with interlocal agreements. You did prepare this nice little the talking points, or you and Dave prepared this on what we can do and what was kind of expected by law in creating and pursuing funding opportunities. Would you walk through that as well?
Sure, I'll be happy to. Before I do that, let me mention one other thing on what you said. As I mentioned to you, part of this potential agreement would be to delineate what those funds would be used for UTA. As I mentioned, they're going to be used to pay off existing bonds and things of that nature.
Right.
And it puts a lot of control back into the county, and particularly the county commission, as it relates to paying off our existing UTA and working towards our existing financial obligations that we have here in the county, if it is approved. And so that's different than what was proposed in Prop 1 in many respects. So, as to the authority to enter into such agreement and even keep local control, as you mentioned, Dave Sharcroft worked on this talking points and essentially, when you have an interlocal cooperation agreement, it allows governmental entities, which UTA is one, and so is the county, to cooperate for a specific reason. And in this particular case, for transit. And so we're allowed to enter interlocal agreements and really have a lot of flexibility in doing so. One of the things that the focus ought to be here is that part of this process is that the UTA is supposed to work with local governments, and particularly Utah County, as looking at the transit needs of the county, and this
and funding opportunities.
And funding opportunities, correct. And this document would help do both those things, help to consult with the county and local government, and also create those funding opportunities. This additional layer of I don't want to call it supervision, but approval by the county is not prohibited by that, by the Local Cooperation Act or any other statute that I've been able to find. In fact, in some ways, you could argue it's more encouraged because it allows for that consultation with local government. And so by adding that provision that the county need to approve new transit authority, new transit opportunities in Utah County, that it seems to be evidencing of working together to make that happen. And consultation.
And the federal government does it all the time.
Sure.
When they say we're going to do some funding, there is a lot of oversight, and this is how it's going to be used and appropriated.
Yes. And even the advisory board that's newly formed or is supposed to review, approve, and recommend project developments, including funding, review, approve, and recommend plans and transit-oriented development with a large district which is involved, and so, and again, this 4/4 cent sales tax is an optional on behalf of the county and the county citizens is what you're putting it to a vote. So it's our view that you could require in this agreement that new transit services be approved by Utah County. It's not prohibited by statute that we've been able to find, and also it even seems to be encouraged in many respects because it does allow for cooperation of local government with the transit authority. So.
Okay. All right. I would like to give Steve an opportunity. He's from UTA.
Good morning. Steve Meyer with Utah Transit Authority. Thank you for the opportunity to comment. As was stated, the agreement talks a lot about the fourth quarter and how the repayments would go forth to the county to repay the debt that the county's incurred on the third quarter for the bus rapid transit project. and we wholeheartedly agree with that. And in effect, that frees up money, additional funds for the county to use for road projects that had been dedicated to the transit project. We think that's good for everyone. Our buses run on those same streets. I think our questions come in, or in concerns on item 3 in the issue you were just talking about with new transit service in the county. The statement, how that's written, is broad, and it appears like it would apply to all quarters of the first quarter, second quarter, and fourth quarter.
Sorry to interrupt, but Steve, could you speak into the mic just a little more? I can barely hear you.
Okay, sorry, Commissioner. So again, the concern is that it can be interpreted fairly broadly that this applies, item 3 applies to the first, second, and fourth quarter. I don't know if that's your intent. We already have interlocal agreements, I believe, at least for the second quarter. And then the first quarter came in city by city originally. And so our desire would be to concur that that applies to the fourth quarter.
That's interesting. I never, personally, I thought we were talking about the fourth quarter. I never thought we were talking about first or second quarter in this, although I like that. But I think that is a subsequent conversation that we'd like to have with a service level agreement. That was always my intent anyway, is to work on a service level agreement that we have in place for those other quarters. I was looking at this one specifically tied to the 40% of the fourth quarter.
Okay, so you, and I think we
I don't
can.
know, were you thinking differently?
No,
on
I
that?
actually only thought we were ever talking fourth quarter.
Yeah.
Okay. So
No, I'm the same. I only thought we were talking about the fourth quarter with this, so that's the intent for me.
great. So we have consensus on that. That's great. So that's, a bit challenging as we're managing the all service,
Yeah.
deciding which of that is allocated to the fourth, but I think we could work through that. The other issue we have is just with SB 136 and the changes that are being made, we have a new local advisory board. As was mentioned, they have some approval authority on routes and service changes. Some of these can be as minor as moving a bus stop because of a business or residential conflict or a service benefit to relocate a bus stop. Some of these are changing routes, realigning a route. Some of those go as far as a new service, a new route. And so we can get into the weeds quite a bit with that. And
Yeah, but see, that's the part I actually like.
Okay.
There's a new board coming on in January.
Mhm.
If the county enacts it, whichever means we enact it, UTA's first portion and check received is in 2020.
Yeah, sometime in the second or
Right,
third.
so in
quarter.
other words, we enter into an agreement, you have that new advisory board, and in essence, everything's protected, where I know the people that we put forward plan on continuing a great partnership with the mayors and the commission. That was a question we asked of all 10 of our applicants.
Mm-hmm.
There wasn't one of the 10 that didn't agree to that. So to me, it's actually one of the main pros for this.
I think this would dovetail nicely with our service level agreement as
Yeah,
well.
yes.
Is that besides just a funding mechanism on there, we have that communication and cooperation between the mayors, and even if moving a bus stop, I mean, it's amazing how that can affect so many people in a neighborhood.
Sure.
And it'd be nice to have more input from local mayors and others who are, bear some of the brunt of it.
So as part of our change day process, which is what we call any shift that we do 3 times a year normally for service changes, that's a 6-month process for us to identify those stops, those routes, schedule changes, all of that takes place. And there's a whole series of public hearings that take place. So just want to be clear that we've always had a public process for that. We've always had opportunity for public comment. We've always come to the Regional Planning Committee to let the mayors know what's going on.
I want to make sure I
with that.
heard you correctly, because being a numbers guy, I thought you said you do that process 3 times a year.
Yep.
And that process takes 6 months.
Uh-huh.
That's a year
So
and a
you-
half.
No, it happens in April, August, and December.
And you continue the 6 months on just that portion, and then you start that process again on a new one, and then,
So prior to the April change day, about 6 months before that, we're planning
Okay.
that. So that did overlap with the December
so they
change
do
day.
overlap.
Yeah, they
Okay,
do.
okay.
But there's a lot of planning because printed schedules are web-based, talking to the passengers and the customers and the property owners that are affected does take time. So we feel we do have that robust process. So we're still trying to work through what the interactions are with our new board of trustees, 3-person full-time, and this local advisory board, which is new to us. How that process works with integration of this, then with the county approvals. Because we'd like to make that as concurrent as possible, so we're not getting which comes first? Is it the county approval, then go to the local advisory board, or vice versa? So I think that's some detail we'd like to work through. And then just been the opportunity for us to get this in front of our current board right now. They did not have a meeting in July, so tomorrow is the first time I can have discussions. I don't have an action item on the agenda for that. We just didn't get far enough along. I didn't feel like to approve that. So we wouldn't have formal approval on a document until September.
Which is the biggest problem.
For number 20 especially.
Right. Is there any way you could pull an emergency meeting together? I know it can be done.
Yeah, I have to talk to the board chair. I think I'd still, we'd still want to pass a draft back and forth here in the next day or two to get some clarity on a few of these items. What's your drop dead?
Wednesday?
And today?
Well, here's the thing.
Oh, for heaven's sakes, there. Whoa. Anyway, I'm Scott Hoganson. I'm Chief Deputy Clerk Auditor. One of the things that I do is I'm wearing my election hat with this one.
Mm-hmm.
This Friday is the absolute very last day that we can do stuff for ballot programming. And the Supreme Court of Utah is working on that deadline on the proposition that will go on the ballot statewide. This is something that must be done by Friday. I can't print ballots contingently based on that you guys are going to come up with some decision one way or the other. They're either printed or they're not printed. And if we have shilly-shallying around about what we're going to do, it's going to delay getting everything programmed, everything printed, and it'll delay getting the ballots into people's hands potentially. So I have to emphasize the need for haste on this and to get this done.
Okay, so prior to Friday, okay. I have a scheduled meeting with our board chairman by phone. He's out of town, but I can speak with him this afternoon and see what we can do.
So it would look like to me then, well, I don't know if are there other comments on this issue?
Well, are we gonna bring it up to the commission first? Before public, or I can't remember how we do that.
Well, we're on the item, so if there's any public comment on the item.
That's what I mean. Do we wanna have a
Oh, bring
commission
it back up.
discussion and then
Yeah.
let the public
Let's do
weigh
that.
in?
That'd be fine.
Cause I
We'll
got a couple thoughts.
Let's bring it back up here to the table
And
for the
it may
commission.
save some comments. So first off, I'm very supportive of this resolution. Again, I alluded to, not that the commission is 100% agreement in the language, I don't know, because I can't speak to that. But I know as far as local control, we are. I believe personally that the reason that UTA is hesitant on this is I think Utah County is the leader on this, and I think this is the new way of doing business to force the service levels, because I believe that more than half the state, meaning Salt Lake and Utah County, when it was on the ballot, spoke out and said, we're in favor of local roads. This is the feedback I got. But we no longer trust UTA with their financial, which is why I believe the legislature heard Senator Scholes led to SB 136, and that's why we have what we have before us. Part of what offends me in some of the comments that were just, that have gone back and forth is UTA putting forward saying that the fourth quarter cent helps us for the bond repayment. When I came into office, Commissioner Ivey, you may want to mute that. We're getting that pretty good. When I came into office, BRT was, if not the most pressing issue for most people, that and TSSD were kind of the two hot points when we came in. It was represented to me by former commissioners who were all involved in the approval of that, because it wasn't us that approved it, it was before, that UTA always comes in ahead of time on projects. The projects get done, they'll be repaid. At that time, it was talked about the bond being repaid in either 2025 or 2026 early. All I've seen in the agreement for the fourth quarter back and forth from UTA is that exact same thing in writing with a new source of funding, which fundamentally I'm opposed to, because there are three people, board and high-ranking officials at UTA, that have all come to me with concerns about finances, which is why my vote for our new board member, one of the people, I was looking a lot for financial. Obviously, that was important to me. Another thing that, so there, and by the way, using the fourth quarter to pay off, there is no financial benefit. Utah County actually loses. We gain nothing financially from using fourth quarter to pay that off. We actually gain money, which is why the majority of mayors supported BRT, because we actually make money, and there will be a windfall, if you want to call it, and it's hard to say that with taxpayer money, but there's a windfall that comes at the end of that bond repayment that allows us to get caught up on a slew of transportation projects in 2025, 2026, whenever that is. If it goes to the end, it's 2028. So there's no financial benefit, period. Steve talked about, you know, we want to enter into this agreements because the buses are on the same streets. That's the one that bothers me more than anything said. It is true. We need to be partners because we're on the same streets. Part of the bond on BRT is the O&M, and it's something the public hears a lot about is the O&M, the operations and maintenance of the buses. It's true, the buses cost to go. What's not in UTA's O&M and where we ride on the same streets is the O&M, none of that fee goes back to the cities who are responsible for the roads, or UDOT or the county. Any roads those are driven on, those O&M fees do not go back to the cities, which forces the cities in their budgets to pay for the road maintenance, which we all know when buses, big rigs, and all those things ride on roads, they wear out earlier. So we're forcing our citizens. We keep talking about how local control and local roads, you know, we're way behind, we're way behind, we're way behind, but yet we keep going. Our citizens spoke very clearly, and the couple of mayors that asked me to vote to put the Prop 1 on the ballot, I was very clear when I said I will put this on. I don't believe it'll pass. The whatever we talk about when they sample people, can't even, the surveys all said that it wouldn't pass. In fact, the survey said it would pass, that it would fail 55-45. Ironically, that survey was right on the mark. But I told him I would never put it on the ballot again unless it was different. It's not different. Our citizens have spoken. There's no reason to even put this on the ballot. There's no reason to do this. Our citizens have 100% spoken and said, UTA, no, we want local control. I believe our citizens are ready and would support. Had there not been a UTA component, which is why the commission worked so hard with the legislature. Amendment 5 was the one we all supported because it gave 100% local control. I believe we would have actually enacted it right off the bat, even with the bribe in there, because it gave local control. I think that's what the citizens of Utah County and Salt Lake County are looking for, is local control. They keep electing mayors, city council members, and commissioners to make sure we're responsible for every penny of the tax dollars. So the resolution does that. It then would become the roadmap for how other cities and or counties would do it with service levels, because I will tell you that all the mayors I talk to, which I'm mostly a South County representative, I feel like, they're frustrated with the service levels. I've literally had mayors say to me, what in the fill in the blank does UTA do for my citizens? Which is the question they get asked from citizens. So why are they paying the tax? That's part of the problem, why the county needs to have, and it's not the commission, it's MAG, which represents, UTA has actually a seat on there, the commission and the mayors need to have an opportunity to weigh in with our transportation plan, our organization. We know where the growth is. We know where those things are going. We have those conversations that aren't public until necessary of where things are going so that we can prepare the service level that is needed to move people the best way we can at the time. So for that matter, I'm 100% in supporting. I'm okay with the language change on the fourth quarter. I'm not even close to putting it on the ballot because I said I never would. If UTA wants to give us full control over fourth quarter for the next 50 years, which is the legal limit, I would actually enact it tomorrow so that we can pay off bonds, but I don't think they're ever going to get there. And I'm okay with that. That's just me. I don't think it needs to go on the ballot because if it goes on the ballot at this point with the 25% or with the quarter cent without UTA, this thing's going to get killed. And I'm okay with that. I think if the UTA portion is signed over to local control, I think there's enough trust with the mayors. I'll stand by every one of the mayors. I think they're all good people and would do this. And I think the citizens would agree and trust the commission going forward and the mayors to make sure that those tax dollars are appropriately used. So anyway, that's my 2 cents or quarter cents.
Commissioner Ivey, any thoughts?
Yeah, particularly speaking to the agreement with UTA, I think we're super, super close. I like it the way it is. Obviously, there needs to be the emphasis on local control. I do want to make sure the language, though, doesn't move us into local micromanagement. I don't think if you need a bus stop to be adjusted that it necessarily has to come before us. But when we're talking about, major decisions and major projects and things like that, I think obviously we need to have that input, but not necessarily micromanage day-to-day operations. That's why we're sending the names forward and trusting the new board to direct those type of affairs. And so as long as that verbiage is a good balance there, I'm very good with this particular item.
Okay, and I would also echo that I don't think we necessarily need to have micromanaging on it. We don't have micromanaging when it comes to funding of roads. We don't go right down to say, how's the thickness or what's the, it's usually a funding issue, and then we let the experts kind of deal with the roads, the road projects. I do think that it would be wise of us in 3 to change some of the wording to say that this is specific to the potential fourth quarter, and it doesn't tie other ways. We'll deal with that with service level agreements. I feel strong enough that this needs to go back to the people, and I know it's a challenge and I know it's a risk to take it back there in the sense of if it passes or not. But because the people, as I view them as the ultimate sovereigns in our political system, and they were the ones that spoke out on this just a few years ago, that it's important for us to have them involved in this process enough to take it back there and trust what they have to say. And that's the reason why I would be in favor of, if we can get this changed, because if this is signed by the county and by UTA, it's not Prop 1. It's different. I wish it was, there's always ways in which you can think, I wish it was a lot more, but I think this is a compromise in which we can at least take it to the people and say, what do you think? Not that we're trying to say, we want you to pass it absolutely, without any question. I think that dialogue is important for us to have in the community, and see what the people, how they direct us. And I think that's for me, that's the appropriate approach to take. And so I'm in favor of passing this with a tweak there. I would hope that UTA would take it seriously enough to take it back there and do whatever is needed and necessary to address it, so that it would have, because if it doesn't, then number 20 becomes null and void. It's not going to go on. Won't even have a chance. And so, with us having the opportunity to work together for funding issues, I think this fulfills that, and hopefully into the future we have a lot more consideration for locally. I mean, I've had numbers of mayors that deal with transit come up to me just mattered and hornets over things that have been changed, and they felt like they had no input, and they're beside themselves on some of the things that. So this would give us a tie for local control, and at least have the voice being able to be heard, and some teeth behind it.
Yeah.
So
I just wanted to address two things you said. I don't disagree with anything you said, actually. The only reason I would enact it if we had the control is because, even though it's a bribe, several $1 million to pay off the bonding, to me, is important. I'm not saying I oppose to anything going on the ballot, but this is kind of, right now, I'm kind of fed up, and to me, it's not fed up at Utah County. It's kind of a federal issue. I'm so sick and tired of hearing people. I love the commercial. There is a school, and I won't promote them, that runs a commercial on the radio talking about what form of government we have, and we're a constitutional republic. And I'm getting sick and tired of watching the news and media and everybody talking about how we're a democracy. We're not. Democracy means everything can go on the ballot and has an option for the county, or for the people to weigh in. Literally, if we're democracy, that means you could put murder on the ballot and the people can weigh in, and if 51% of the people say murder's not illegal anymore, it passes. That's not what we do. We are representatives. So it's not that I disagree with the citizens having a chance to weigh in. I believe you do that through our elections. I think you've actually already spoken on this, and that's why I think if UTA component is controlled, I think they're supportive because of the millions. Again, it's not because I'm opposed to it being on the ballot for people to have a say. I just feel that way, and again, that's my belief. Not everything needs to go on the ballot as long as we know where the people are. And in this case, I believe the majority of Utah County residents support local control, support additional money for local roads, but local roads and local service levels. That doesn't mean everybody, because there are some who never want to see us raise taxes, and until they feel 100% comfortable on every penny, and I don't blame them. That's a fair argument to have. But that's why. It's not that, I disagree with anything you're saying. It's just more my bug these days with the national conversation, so.
All right. Any more discussion up here on the bench?
No, I'm good to move forward with this one.
Okay.
So we'll open up.
We'll open it up for any comments. Go ahead, Steve.
Thanks. Steve Meyer again with UTA. Just a clarification, the bonding does not cover the O&M. You can't bond for operations and maintenance. You have to bond against an asset. So it does come from the third quarter.
And I'm sorry, thank you for the clarification. It's out of our third quarter that we're covering the BRT O&M.
The agreement still talks about the same time frames as the funding ILA. Just to be consistent, it's our desire to pay that off sooner, as we're seeing continued growth in sales tax because of the growth in population.
But we can't pay it off before the call date anyway.
Right.
Call date's like
correct, but we're
stuck to that.
We can take over the payments. We could take over more of the O&M cost and free up that money for you. So that's our intent there. Thank you.
Okay, any others? Looks like you're...
Hello, my name is Jen Ottens. I was here last meeting. I've been spending quite a lot of time talking with my friends, my neighbors, my acquaintances, a lot of people I don't even know. I'll be spending about 4 hours tomorrow on the phones talking to people about these tax increases. There are a number of tax hikes that have been proposed, including a large state gasoline tax and another tax proposed to expand Medicaid or Medicare, the medical issue, and as well as this one. And we are taxed to death. We've had it. Perhaps I'm the first to admit that I'm probably not the sharpest tool in the shed, but it seems pretty interesting to me that it seems like UTA is saying, well, if you just give us this extra 0.25%, then we'll start paying on our bonds. And it's like, shouldn't you already be paying on those? I mean, you shouldn't have to enact another tax in order to start paying on obligations that you made before. And, as a citizen, it seems to me as if the federal government has given us small tax reprieve for the moment, and that the state and everybody else has now made a rush to see how much of it they can take away from us. So it's like the federal government gives us a little bit with one hand, and the state's going, ooh, let's take this much and this much and this much, to where we end up with no real relief at all. Now, the one thing that does encourage me is the number of businesses that I see who are hiring people. And right now, with the tax relief that we've been given and the encouragement in small businesses, and I myself have recently started a small business, and I hope to be hiring people in the near future. But every time you raise taxes, you slow that down. And I have had one person out of all of the people since the last meeting that I spoke at, I have had one person say, well, you know, I think I might want to look into that a little bit more before I go ahead and just say no to it completely. One. Everybody else has said, oh my gosh, no. You know, didn't we just vote on this? Didn't we say no to this? And I realize that it has changed some, but I'm not certain that it has changed enough. And things have not changed enough for us at the bottom end. And at least I'm encouraged by the hopes that it will at least be placed on the ballot rather than just be summarily thrust upon us. That gives me a little bit of hope. But as far as I can tell from an honest personal perspective, having spoken with so many people, and I'm kind of new at this, but I'm going to become a lot more active. I sat around and let other people do this for far too long, and look at the mess we're in. So I think every individual is going to have to step up a little bit and become a lot more personally involved in our local government as well as our state and our national government. And so I'm just saying that we're overwhelmingly opposed. We're opposed to it. I also have a question. If this kickback or bribe or whatever you want to call it,
Sure.
Is that just for 1 year?
It's from,
Is it for
had we,
every
we were
year?
allowed to enact it as a commission, I believe the date was July 1st.
Ah.
And we could have done it for July 1st, and so it's from that period until the end of 2019. So whenever the tax were to be enacted, it would end.
Just till July,
Just
June
until
31st,
and then December 31st of 2019.
June. It only goes till.
Oh, till June, yes, 1 year, sorry.
Okay.
1 year
So,
portion.
so you'd get a little
if we don't
kickback,
enact
and
it till
then,
January.
then this big tax would continue on in perpetuity forevermore.
And then it
going
gets
to
splits
UTA.
up. Well, and the cities and the county.
Yeah.
Oh.
Okay, well, I'm just saying that so far as I can tell, and I'm one of the few people that can control my schedule well enough to be able to come and speak to you. I'm not a great speaker, as you can tell, but people have entrusted me to come and say, hey, we're not for this.
You're
We're
doing
not.
great.
Well, thank you very much. I appreciate
I'd just
that.
like to explain something to you on the finances, so you
Thank
can
you.
maybe have other
I
comments.
want to be sure and
So,
explain the truth.
BRT was passed, and again, before Commissioner Lee and I got here, this is why the mayors had to be involved. The third quarter cent that was put into place is a transportation piece. The BRT is funded out of our local roads portion. So when UTA says we will take that fourth quarter, their portion, and pay against the third quarter, in other words, freeing up the money that we already have for roads, taking that and paying out of the UTA portion, and now we have additional money back for the roads that the mayors voted out. So when I talk about the windfall.
That's the windfall.
Yes, because we will get all that back plus interest in 2028, I believe, or 2027. And that's where that $100 and something million that we would get back comes from. So that's the number that comes from what would be local roads that the mayors had to vote on and give up. And that's what they did back in 2014, before we came into office. December, well, November.
Thank you for clarifying that. I really, really appreciate it, and I will continue to study this matter. But as far as I can tell, every person, except for the one, has said that they were overwhelmingly opposed to this increase.
Yeah.
So I thank you
Well,
very much.
our hope is that, you know, they have all the information, and that way they can make a decision based off of the information. And we don't even have the information to give them yet, because we haven't passed anything
Right.
yet.
I understand, and we'll be studying it, you know.
Right.
If it's something that's really, really necessary, of course, you know, we're logical that way. Everybody likes to have nice roads to drive on. It's a necessity. And so we just want to make sure, because this is coming out of everything that we buy, everything that we purchase, every service, everything, it's a sales tax. So this is really impacting people who are low income and people who are on fixed incomes, because their fixed incomes don't continue to grow. And so they just continue to lose more and more. I thank you very much for your time and for the explanations, and
Thank you.
appreciate you.
Any others? Seeing none, we'll bring it back up here to the bench for a motion, if a
So
motion's
I just
ready.
want to make sure that the commission is dealing with the right resolution, because we have a couple. We're talking about and I know the people can't see this on our screens, the third one that says the updated res approving interlocal, right? That's the
Right.
most recent.
Yes. The one that has, under number 3, which seems to be the one that says the new transit service in the county UTA shall coordinate the planning of any such new transit service locally with the county and in
Right.
consultation with the Utah County Governments, that one there?
Yes,
And then it
okay,
goes
I just
on
want to make sure.
Okay.
Okay, so I'll propose this motion, we'll see what happens. I'll move then that we adopt the resolution approving and authorizing the execution of interlocal cooperation agreement between the Transit District of Utah, also known as Utah Transit Authority, and Utah County, with the stipulated change to clarify for the fourth quarter and UTA's adoption by close of business 5 o'clock on Thursday.
Second.
Okay, I've got a motion and a second. I think we're also, well, I see what you're trying to do, because 20 is maybe a little different than what you're anticipating. But we have written into 20 that there is, that if it is not signed by UTA, that it's null and void.
No, I'm not actually trying to do that for 20. I'm trying to let people know, especially at UTA.
Okay.
I'm
I
not
see what
messing
you're
around.
doing.
I've said this from the beginning. Either agree to local control, or let's not be in business
What
together.
you're saying, we agree with this, we're gonna sign this, and now it's on UTA
Yeah,
shoulders too.
that's my thoughts.
Mr. Chairman, can I clarify?
Sure.
So I make sure I'm clear. My understanding was the motion was to include a modification to section 3 that references that it applies only to the fourth quarter.
Fourth quarter.
Okay, and it does not include a modification about, that this doesn't apply to day-to-day operations. You talked about that, but that's not part of the motion. I just want to clarify. That you're not micromanaging them,
Right.
So, do you want that part of it or not? You mentioned you all three talked about that.
Well, I don't think we ever felt that's not what we
Okay.
felt like
I just
it
wanted to
was.
clarify that.
And again, I'm not trying to discount with Steve. I understand his concerns on that. That wasn't any of our intentions. It was always the fourth quarter, and it wasn't to say, hey, you need our permission to do this. We just want to be in the conversation with the mayors.
I
and everybody.
appreciate that. I'm just clarifying that, so if you approve it today, that I can work with the UTA attorney to get this taken care of.
Okay, so I've got a motion and a second on the table. We've had some discussion. Any further discussion on it?
No.
All right, then, all in favor, say aye.
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 That passes 3-0. Now moving to number 20, which is to adopt a resolution of the Board of County Commissioners of Utah County, Utah, approving the imposition of a 0.25% county option sales tax use tax for highways, public transit, approving the submission. Anyway, this, you see it on here. I just want to clarify that this, on this one here, because when you read this the first time, you think that the county is automatically imposing this. That is not the case. What this is that we would be throwing this to the vote of the people. That's what number 20 is about, is letting the people vote on this thing. And if the people come back in a positive way to go ahead and impose that 0.25, then the county commission would then impose it afterwards. That, I just want to make sure and clarify that, because when you read it, sometimes you think that the county commission is imposing right now. This also comes with a stipulation that if the prior interlocal agreement is not signed, that it would not go on the ballot.
So if you, this is Robert Moore again, if you approve 20, you'd want to approve it contingent upon UTA signing the interlocal cooperation.
So here's something that I just thought and popped into my mind, and I kind of alluded to it a few weeks ago when we had a discussion. I don't know, when Proposition 1, which this is Proposition 1 with some amended changes like an unnecessary spending of $50 million for name change, stuff like that in it. Proposition 1 required for all the ballot proposition to have a for and against. Do you remember? My question is that still in?
Oh, yeah, of course it is. And anybody can write that.
I know, but who are we gonna get to be against if we're all in favor of it that way?
It doesn't matter. I mean, somebody will have, anybody can write it from the public if they want.
Yeah, but we can't publish a for, if I remember right, we can't publish a for without an against. You see what I'm saying? Because that's the part I think that where it was against you is because they had prepared the for before allowing you to do an against and start to proceed. That was my recollection. I'm obviously I may be wrong.
My office wrote the against on
Right.
Prop 1. Yeah, I don't know, Scott. Do you know the answer to that? Can you have one without the other? Or is it just?
Because it had to be a balance.
What you do is you give an opportunity for people to do that, like, do an invitation, and people can submit things for that. I have seen ones where nobody submitted arguments against, but that was like, on things that are a little bit different than this. I'm sure the civil division will make sure that we do exactly the right thing on this with the process for this.
Let's see, so the other portion that to me comes with this is potentially is the commission going to spend some money informing people of the change with the UTA portion, right? Because that's an important clarification.
Well, I think that not just the commission, but the mayors and everybody else on board need to go out there and say and demonstrate and I'm not saying they need to go out there and say one way or the other. They need to get the information out.
And that's all I'm talking about. I think it's like school
information
bonds.
out.
Quit talking about hypotheticals. Just
Right.
give the people the facts
Here's
let them decide.
Here's what the facts
The
are.
true facts.
Right.
Right, I fully agree with that. The people need to be informed that this is a different option.
Yeah. So, because if necessary, I think the commission should potentially put out its own piece on the facts as, prepared and
Right.
potentially publish something. So
I
anyway.
think we have a responsibility to do that either way.
Sure, I agree. So,
Now I'm lost in the process. Where are we at? We never
well,
got a
you're
motion
probably
or
ready
anything,
for a
right?
motion.
Yeah, okay. I'm ready for a motion.
Just for sake of moving this forward, because I've kind of already said where I'm at because of what I said in Prop 1, I will move that we adopt the resolution as stated in number 20 with the stipulation that UTA's acceptance of number 19 is done in that timely manner. And you said one other thing, Rob.
I was just saying it's contingent upon UTA.
Okay, that was the only thing.
Yep.
Okay.
Second?
I've got a motion and a second to adopt the resolution with a contingency upon UTA accepting the resolution that was already just approved. All in favor, say aye.
Aye.
Any opposed?
Aye.
That's a 2-to-1 with Commissioner Lee and Commissioner Ivy.
Just to state again, I'm not opposed. I just made a promise 2 years ago I was never going to put this on the ballot again.
I respect that. I feel strong enough to put it to the vote of the people.
Yeah,
that I'd like to see
I'm
it
not
go there.
opposed to that.
Okay. Let's see, we are at the end of our regular agenda there. We do need, we can strike number 21, unless there's any commissioners that need that on there. 22, 23, and 24 will be needed.
Okay, I'll move then that we strike regular agenda item 21.
Second?
I've got a motion and a second to strike agenda item number 21. All in favor, say aye.
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 That passes 3-0.
I will move that we approve and set a date, time, and location for a closed meeting for a strategy session to discuss the sale of real property, water rights, or water shares previously publicly noticed for sale for today's date at this location following completion of regular agenda and work session items.
Second.
I get a motion and a second to approve and set a date, time, location as stated number 22 on our agenda. All in favor, say aye.
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 That passes 3-0.
I move that we approve and set a date, time, and location for a closed meeting to discuss the character, professional competence, or physical or mental health of an individual or individuals for today's date at this location following completion of regular agenda and work session items.
Second.
And a motion and a second to approve and set a date, time, and location as stated number 23 on our regular agenda. All in favor, say aye.
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 Passes 3-0.
I move that we approve and set a date, time, and location for a closed meeting for a strategy session to discuss pending or reasonably imminent litigation for today's date at this location following the completion of regular agenda and work session items.
Second.
And a motion and a second to approve and set a date, time, and location as stated number 24 on our regular agenda. All in favor, say aye.
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 That passes 3-0. You have a couple of work sessions. The first one is a discussion regarding the American Fork Redevelopment Agency creation of a community reinvestment area.
I don't know if to address you by chair or acting chair today. Just for a time constraint, and I know a couple people, I was wondering if we could move the public comments ahead of that. I have another obligation that I have a meeting at 11:45 so that I can make it back for the swearing in. I was wondering if we could switch that order today.
Yeah, I don't see any problem with that, considering that work session items are just work
Right.
sessions in which we have discussions. They're not actionable items. And so if there's any objection to that, seeing no objection to that, then we do have the 2 work session items, but we'll move the public comments to before the work session. And so we'll open those up for public comment. Oh.
I don't believe so.
If a work session item requires electronic setup, now would be the perfect time to do that. Seeing no public comment, we will close the public comment portion.
I'm sorry. You think you're still doing work session technology?
Oh, no, we were on public comment. Okay, so public comment, come on up. So I know it can get confusing, but if we start going, just raise your hand and say, wait, hang on, time out, find out where we're at.
Sounds good. Thank you so much, and thank you for your service to the citizens of our county. My name is Ben Reeves. I'm the Santaquin City Manager, and earlier on the agenda, you had something that you continued with regard to mining that I know has an impact on both Santaquin and Genola and the residents of Utah County in that area. Santaquin City is gravely concerned.
Ben, I'm sorry to interrupt you. If you will take that mic and tip, no, just the tip actually tips, and tip it down. That way Commissioner Ivey can hear it more clearly, so it's just a one-directional mic.
Okay, very good. We're gravely concerned about the proposed mining operation as it's currently proposed, and we respectfully request the Commission's consideration requiring a more comprehensive operational plan than the one page that they provided to mitigate any negative impacts to our orchard owners and our residential neighborhoods before any approval is considered. The petitioner has contended that they are a large mining operation, and it's Santaquin City's belief that they currently have a small operating permit. And while they may or may not be able to expand that through approval from DOGM, any change should be considered a new use and would justify the Commission's consideration to require a more comprehensive operation plan to mitigate any negative impacts. The plan at a minimum should be more comprehensive in manners to address dust, noise, light, blasting, hours of operation, transportation impacts, and most important, to mitigate the potential impacts to our agricultural industry, especially the orchard owners. On a final note, their current plan illustrates that they are screened by a hillside, but that same plan, they are planning to take down that hillside in the mining, and so their plan is deficient in that manner simply because they're going to eliminate their own screening operation. As currently proposed, Santaquin City is opposed to this mining operation, and the Commission has received a letter from our City Council and our Mayor on this issue. So we're just appreciating you and all that you do and helping to make sure that our residents are protected.
Just for clarification, the reason why we continue that work through a claim of vested interest, you know, a vested claim, mining claim, and so we wanted to make sure that that was taken care of and we knew exactly what we're dealing with before we deal with anything.
Yep, thank you.
And
Yep,
that's where
we're
we're
aware of
working.
that.
I got one more thing, and not that I try not to comment on your comment. You said currently opposed to the application, which would tend to make me believe that if some certain things changed, and I know you stated some of those, I was wondering if Santaquin City would be kind enough to put in writing all of the required, and I don't remember that in your letter, of what the changes you would like to see. I saw the opposition letter, but I don't remember that part in it.
We would be happy to do that. We could put that together. It's important to note that this applicant originally came to the city for potential annexation, and the city on 2 different occasions accepted that application. They were deficient in getting things in on a timely manner, and so those applications went defunct. Santaquin City recognizes that there could be a continuation of the Summit Ridge subdivision area, and even some mass grading that could perpetuate the continued growth of the residential area, and done so in a manner that it would mitigate any impacts to the orchard owners. But it became concerning to our citizens and to our neighboring community when that proposal for some simple mass grading turned into a true mine, and then asphalt operations and impacts that were very closely co-located to our residents and to the orchards. So,
Thank you.
Mr. Chairman, just to clarify, reason was continued was because the applicants are trying to prove they have a vested mining interest. If they can prove that, then it would not require an operational plan. I want you to understand that, because so they would not be back here next week.
And
if
it
they
would
can,
not
in fact,
require
prove
Even
that,
with our new ordinance?
it's a super protection. It protects them over and above any changes to the ordinance, and they would be in effect prior to our ordinances that went into adoption. They are working to prove that up right now under state law. This is not county law, it's state law.
State law.
Yep. It's like an ag protection area in a way. It's for mining purposes related to minerals, not related to gravel and those kind of things, but like they're mining limestone. So that's what they're trying to do. If they can prove that, then it changes things under the way we have to look at it. And so that's what they're trying to do. I've actually been consulting with Santaquin City Attorney on this as well and discussing that issue with him. And in a lot of ways, if they can prove it, then he understands that that's, at least it's my discussion with him, that they would probably be entitled to those things. So.
Good morning. My name is Josh Nielsen. I'm the attorney for the town of Genola. I'm here essentially just echoing what Santaquin City said on behalf of the citizens of the town of Genola. I just finalized with the mayor of Genola a letter this morning, which I brought copies of to give to you, that essentially echoes what the Santaquin City said, that the town
You're
of Genola.
okay with these being public documents?
Yes. Echoing what Santaquin City said, the town of Genola is concerned with the operation as currently planned and proposed. We would ask that the commission, to the extent that you are allowed to take action, given what your attorneys just said, that you impose some restrictions and requirements on them to mitigate any negative impacts on the town of Genola and its residents. So just wanted to share that with you today. Thank you.
Thank you.
All right, still in public comment, come on up.
My name is Eric Hazlett. I have no authority in this matter, but I used to be the mayor and planning commission chairman of Genola. So just for some background there, because some of the things I'm gonna ask for might sound hypocritical. So we have a existing business that would be severely impacted by this. And obviously if they have the super protection, that might override any of the concerns I have. So I totally understand what you're saying. However, with the existing businesses, which I have no part in, I don't own any orchards or employed by them. However, if they are impacted by dust, chemicals, et cetera, by this facility, that could really impact their business. And so they already have a business and they're entitled to their livelihood, so I wouldn't like to see that impacted. And in the past, where you've seen things where people have built businesses on the outside of a town, and then people live around, they move in around it, that's one thing. Well, the people already live there. So this is an impactful business being put into where people already live, and I'd like you to take that in consideration if possible. And then here's the hypocritical part. When I was helping with our community before, it seemed like environmental impact studies would get in the way. But I think in this case, where it's impacting an existing business, it might be something to look at to the extent that your planning commission can do that and see what kind of effect the chemicals and dust produce against the fruit that the orchards grow. Because that is a significant business in our communities. And also at the very end, I know that when we've had other petitions where we've had to come to the county to get help for in the past 10 or 12 years ago, there was impact on property values was also taken into consideration. So if those things could be taken into consideration, we'd appreciate that. Thank you for your time. Appreciate it.
Derek. Still in general public, there we go.
My name's Brandy Fitzgerald. I'm a Genola resident. If you can take back just a few months ago, there was a presentation done by the Rollies. They are orchard farmers in Santaquin. A non-public comment, the Fowers also spoke. They're local farmers. So if you can take yourself back to that meeting, this was the property they feared was going to come in and alter their livelihood drastically. It could drastically change the economic income of Utah as a whole because of the orchards are Santaquin, the surrounding areas. My backyard in Genola backs up to Highway 6. Truck traffic coming through maybe from Delta or the garbage trucks coming from, taking the garbage out to the dump. Highway 6 is getting to be kind of a dangerous stretch right there. You're gonna have where, there's no map here, you can't see, but where, from what we can tell, the crazy map they gave us, where the trucks will be coming out onto Highway 6, that's a 60-mile-an-hour highway. So you're gonna have a loaded truck pulling out on a 60-mile-an-hour highway. The cars or buses, big trucks are already traveling at 60 miles an hour, if not faster.
I was gonna say faster.
So you're gonna have these trucks pulling out at what? They might be in second gear trying to pull the grade into Santaquin. It's not a good combination. You're gonna have trucks coming up out of Goshen. You're gonna have trucks dropping down from Santaquin that are already flipping Jake brakes trying to slow down from 60 as they go into Goshen. That's school bus routes. My kid drives to high school on that road. It's wintertime. That to me is a huge, well, how are we gonna fix that? I mean, Highway 6 is my backyard. And before I bought the house, there had been cars that have already slid into my backyard, taken out fences. I had got horses in that area. So that's one extreme concern I have. Summit Ridge is expanding. They're putting in another exit way of Summit Ridge that's gonna spit out on Highway 6 just a little bit further up into Santaquin. It's gonna be a row of trains just trying to get in and out of town. And I don't know exactly the amount of traffic we're talking or how much this operation. But once you get your foot in the door of being allowed, well, they're gonna want more, and they're just gonna want to expand because no gravel company doesn't. So that's an extreme concern. As my children are on the road, that's the only way in and out. So that's something to drastically consider. It's a highway, it's a 60-mile-an-hour highway. And those trucks aren't gonna pull out on Highway 6 going 60 miles an hour. So we're gonna have major traffic concerns. And my friends, my neighbors, their livelihood, generations that have been there, that have staked, that have worked their entire lives, their families, their kids might want to be brought up in it. It could jeopardize it. It makes me emotional because I love my community. I love what it stands for. You know, there are farmers in Utah, you know, there's getting pushed out left and right because of things coming in and choking them out. But this is a huge industry for Utah. And the apples and the cherries and the peaches, those orchards are right there, and the way the wind blows, there's, what water do they have? What can they do to mitigate all of these impacts? There's no water there. I mean, we had just a tiny brush fire started on the North Hill in Genola, and it grew to 100+ acres in nothing flat. And there's a couple of homes up in Genola up on the hill. If something like that was to happen at that pit and it went to Summit Ridge, you've got hundreds and hundreds of homes. And this is literally in their backyard. You've got all of Santaquin, you've got Genola, and you've got this little pocket of Utah County property. That's Utah County. And I just think, how is it one company's right to come in and be able to possibly negatively impact two entire communities, not just necessarily just the neighbors that will hear it, but the dust, it blows. And what are they gonna do on the weekends when the wind blows and no one's working? So Genola, Santaquin, we definitely have legitimate concerns when it comes to this operation. Thank you.
Thank you.
Hi, my name is Robin Colson. I live in Genola. I always work in Santaquin. I know that you are well aware of the impacts on the orchards and things. I know you've dealt a lot with the issues on West Mountain. And because you have, I think you're aware of the dust, the noise, the traffic. I would just like to be on record saying that I would oppose any larger expansion of what they are proposing, because they are coming in and all these residents and orchards have been there prior. And so I would just like to be on record saying that I oppose that.
Thanks, Robin.
My name's William McMullen. I currently
Great first name.
Thank you. As they talk about orchard growers, I'm actually the one that's right next to the pit. My home's less than a half mile from the pit. Third generation farmer, hopefully going in the fourth generation's really wants to take over. And we'd like to continue that. We don't want to put in homes. We're one of the largest landowners in southern Utah County with two farms we have on Lincoln Beach and in Genola in the West Mountain area. Majority of it's in county area. We'd like to keep it going, fourth, fifth generation if possible. My other orchard that I run is right next to Keeley Quarry. And of course, Keeley Quarry was there when we started in 27 out there. They moved in. We have seen over the years, you know, we could take pictures of when it rains, the mud coming off the leaves of the dust. Because the wind, the tendency to wind comes from the southwest and it blows right up and over and onto our trees. When Valley put this pit in, back in I can't remember, the 90s, we did see an influx of the dust on the leaves, more spraying, being on it's I can't say every year. Depends on the heat, when the mites might show up, but the dust aggravates that. I know the blasting, I could show you a rock that they actually blasted, went up and over the mountain, came down and broke one of our cedar posts. So that's a concern. We do have cracks in our sheetrock from, we didn't have before when they blasted it. We do have new cracks in our sheetrock. Other than that, from my wife's aspect, is dusting. Since the pit was, before it wasn't bad, then after the pit goes up, every morning there'd be a fine film of dust on the furniture. So it has been nice since the pit wasn't there on her chores, I should say. But I would like to go on record for McMullen Orchards. We oppose this. Thanks.
Thank you, William. Still in public comment? Any others? All right, seeing none others, we'll pull it out of public comment, bring it back to up here, and move into our work sessions. First on our work session is to discuss regarding the American Fork Redevelopment Agency creation. Thanks for coming. Make sure you sign in if you haven't.
Renee, you can call me for the closed sessions, and I'll just watch these online. Make sure these are on YouTube, these work sessions. YouTube's, so I can make sure I catch back up on them. Thank you.
How are you? Good to see you. Good to see you. Thank you. Thanks for coming.
Thank you for your comments.
Do we have those that are here for the regarding the redevelopment agency?
Lisa has it.
Okay, I don't see anybody for that work session. We will, I don't know who to ask to go back and ask them if they just forgot. Rob, will you do that, I guess? Since it does have Dave on here.
Yes, so it was actually, I think, Dave got an email from Cody Hill saying that they would be here today.
Okay.
So I'm not sure.
All right.
So we can
Okay.
follow up with that and continue in a couple weeks.
Okay.
We'll just bring it back on, just strike it.
Yeah, we'll just, I don't think we have to strike, it's just a work session, all right?
Okay.
We'll just bring it back up.
Fair
So we'll move to the other one then. I know they're here, I see them right over here. It's a update from Spanish Fork City regarding the River Bottoms Vision Project. I know we've had some discussion on that, and I thought it would be wise to bring you back up here and talk about it.
Thank you. I certainly appreciate the opportunity. You remember that back in January of this year, myself
Be
and
sure
one of
and
our...
just state your name just for a record.
Thank you. So I don't forget, Dave Anderson with Spanish Fork City. Again, earlier this year, we were here and had an opportunity to speak with the commission about a project we were just starting. A project that involves some land that is currently, for the most part, south of Spanish Fork City. Encompasses nearly 2,000 acres. We call it the River Bottoms. The land that we're working on is in Spanish Fork City's annexation policy plan, but like I said, still the majority of it is in Utah County. And I'm gonna really try to be very succinct today. I've had a long morning. In short, we're about halfway through the project. We did some very extensive public outreach work in the spring in the hope of getting a very comprehensive look at what people's interests were for the river bottoms, or are for the river bottoms, as much as anything, so that as we progress from where we're at now to trying to develop a plan for the river bottoms, should it be annexed into Spanish Fork City, in terms of land use. So just to be clear, the project that we're working on now really is just about the future land use for this area and what should happen there. Over time, or I guess I should say even from kind of the beginning of time as we know it in terms of land use planning in Spanish Fork, the plan for the river bottoms has been for it to be annexed and to remain agricultural land. And over the course of the past couple of decades, the number of requests that we as the city have fielded to have land annexed into Spanish Fork expressly for the purpose of having development happen there, they increase seemingly every year. For that purpose, we're doing the project now as almost something of a check on that concept of should the river bottoms remain agricultural land? Is there room perhaps for something in addition to agricultural activities? Is there an entirely different concept that should be pursued? And in short, again, like I said, we've posed several of those questions to both people that have a direct stake in the river bottoms, that is property owners, people that farm the river bottoms, people that have development interest in the river bottoms, as well as just the general community. And we've received an excellent response to the outreach that's occurred. Currently on our website, we have some of the very raw survey data that we collected as we went through different parts of that process. And we have some more refined data. Logan Simpson is a consultant that we've hired to help us with this project. I think they've done an excellent job of asking the right questions and getting the right feedback from different people. And to that end, as I mentioned a second ago, we're about halfway through now. And we are doing something of a check on the information that we've received in the hope of making sure that we're on the right track before Logan Simpson goes to the next step of preparing an actual draft land use plan for the river bottoms. And to that end, something of just an update today for the commission relative to again, where we're at in the process, as well as an invitation. If there's any information that we can provide to you or your colleagues, we're certainly happy to do that. As we go from where we're at now to getting things that are a little bit more refined and that probably start to have more meaning. We'd love to have more dialogue with Utah County, really from the perspective that we believe we're certainly in a partnership with the county, at least short term, maybe for a long time, relative to what happens in the river bottoms. And we want you to be a part of that project or this project as much as you'd like to be. So again, that's just something of a brief update. I'd be happy to answer any questions that you might have. I have hard copies of a vision document that again is intended just to be a check on the, thank you.
Is that the same one that you?
It is, yeah, hasn't changed at all.
This is all public. We said it on your.
And again, that and quite a bit of other information on the project is available on the city's website.
I think if I could just, from going through this and talking with you, I think the sentiment came back pretty overwhelmingly, from what I gathered anyway, that the agricultural base and keeping that quality is pretty strong from the survey that you took. Is that a fair representation of?
That is certainly how we read the data, and maybe just to comment on that. Honestly, that's not a big surprise to us, particularly for people that don't have a direct stake in the river bottoms. People that maybe own homes that overlook the river bottoms that, for reasons that we can probably understand, don't ever want to see that area change. We really anticipated that they would say, leave it alone. Don't allow development in the river bottoms and those types of things. What perhaps was a little bit more of a surprise for us, however, was that among the stakeholders, people that have a different kind of interest in the river bottoms, either as property owners or something else, we also, for the most part, heard that same sentiment from them. And that is something of a surprise to us. We know that things change over time, but particularly in light of that, we're working with Logan Simpson now to try to come up with options, perhaps to provide the folks that we know really would like to see some development happen in the river bottoms, some way perhaps to have their needs addressed and satisfied while maintaining that open agricultural use that's so prevalent today in most of the river bottoms for as long as we can keep it in the future.
Okay, great. Thank you.
Thank you.
You have, we do have a lack of a quorum right now, but we'll be moving into our closed meeting, and I think they're gonna come up in our closed meetings, and so we'll be able to finalize our agenda at the end after we open it back up. But right now, I just want to note that we do have a lack of a quorum.
Yeah, we also, after our closed meetings, we come back out, of this meeting, we do have a White Hills Special Service District meeting.
Yes, which I'm hoping that we have a quorum for.
I hope you do too.
I think we would.
I think you do. I know Commissioner Ivy said, please call him back.
Okay, good, good. So with that lack of a quorum, we will move into our closed meetings.
No, other way.